Oh,
to
thank
the
you.
LSU game. Student ticket.
I was like, I should write you up.
McDill? McDill? Who's there? Reed? No? Mr. Smith not here today? Mr. Walker?
Hey, did you get me? I didn't hear my name.
I got you. I got you. Yeah. I got Stacy too. Okay, couple things. Maybe I should have explained further when I sent the email yesterday, but I was excited about getting the deal. That the Spring Hill Suites deal for you guys that are way out of town, right? That's good indefinitely going forward. Okay, so if you need to come, if you want to come on Friday night and study with your friends and get a room at the Spring Hill Suites, that's good. That's not just for the social, but that's good going forward indefinitely. So that's something we've never had. Come to the social tonight. We didn't, the 1Ls on the weeknight really didn't turn out, I guess because they didn't have class on Thursday. But we had a ton of food, and those that did come, we had a good time. So we have our own little watch party with a big digital screen in the back at Sidebar, so that'll be fun. At least for 3/4 until they take 2 out of the game. Kidding. We're going to do actual calls this week, proximate calls next week, and we'll get into intervening causes and joint tortfeasors a little bit next week, but we'll cover joint tortfeasors the last week as planned, and then there will be what is a cursory review for about 45 minutes on the last day, okay? This final is December the 8th, correct?
Yes.
So that's at 9 a.m., so don't mess that up. Don't come at 12:30 expecting to find me with your test. Okay? So we're good? Oh, and I'm almost done with the essays. I do this, it happens. What I realized, I probably would have been able to finish them this morning had I not realized yesterday that we had 60 applications that needed to, letters needed to be sent. And so I spent all day yesterday with the spring applications. So that's what happened there. Can't apologize for that. Next week, proximate cause is the headiest class of both terms. So hopefully you won't miss next week. So I am on 273. Hello, Mr. Walker, looking sharp today. Who's got Perkins? Ms. Collins.
In Perkins, the plaintiff has been Tanner Perkins was traveling. He was hit by a train in the town of Vernon.
Louder.
The train was traveling at a high speed of 37 miles per hour. The engineer and the crewsmen were aware of the railroad safety regulations imposing a speed limit of 25 miles per hour was a safety mechanism to control the train. The testimony of the witnesses in the hopeless conflict as to the speed of the automobile.
Well, wait a minute now. Let's slow down. We got to be kind of particular with our facts here. You said the train's doing 37, right?
Yes, sir.
And were
The automobile.
Hmm?
It was the automobile. They could not testify to the speed of the automobile.
That's right.
Yes,
Train was doing
I
30.
apologize for that.
Right.
Yes.
Okay, bear with me now. Hang on a second. All right. So, what is the problem? Were the mechanisms at the railroad crossing working?
Yes.
Yeah. Okay. So, what's our problem here? Why couldn't we see? Why did the train not see the car until the very last second? Got that part? There's a big warehouse, right? So we have an obstruction, right? And it's a big, long, tall warehouse. Okay? And you said that there was a speed limit, and what was that speed limit?
25.
It was 25. But what's funky about that speed limit?
It was a safety mechanism that was put in place.
It's self-imposed, right? So we don't have a statute. We have a self-imposed speed limit by the train company, right? Otherwise, if we did have a statute, this might be a case of, don't blurt. If we had a statute that limited the speed to 25 miles an hour and the train was doing 37, we might have a case of help her out. Negligence per se, right? Negligence per se. There you go. Okay, and we don't know how fast the car was going, but we do know the train was doing 37. Now, keep going.
The issue is whether the excessive speed of the train was a cause, in fact, of the fatal collision. My rule is negligence is a cause, in fact, of the harm to another if it was a substantial factor in bringing about that harm.
That's right.
Okay? Then, district court ruled in favor of the plaintiff for damages. However, the Court of Appeals reversed and the plaintiff's suit was dismissed at her cost.
That's what was the last part?
At her cost.
Oh, okay. Yeah, keep going.
That's all I got so far.
That's all you got?
That's all I got.
That's all you got?
That's all I got.
Okay. So why, well, I hope you got a little bit more.
You give it to me.
Okay. Why did the appellate court reverse the decision of the trial court in favor of the plaintiff?
Was it because they didn't
Think about it.
I was going to say this.
They said, the one thing we left out is that the engineer said that they had there was a little bit of discrepancy in the testimony, but the engineer said they only had about 40 feet when they appeared, when the engineer saw the car, right? And did the engineer of the train act reasonably by putting on the emergency brake as soon as they saw the car? Right? Yes. What's the problem? Wait a minute, stop. So why does the defendant get off the hook here? No, just let her think. All right, Ms. Williams, go ahead. Right, that's it, right? Even if the train had been doing the speed limit, right? The fact that they were so close to the car when it came into view didn't matter. And therefore, the breach of the duty to abide by a 25-mile-an-hour speed limit, self-imposed speed limit, was not the actual cause of the accident. Even had they been doing 25, right, when the car appeared from behind the warehouse, they wouldn't have been able to stop in time anyway. Okay? So the negligence, the breach of the duty to maintain a certain speed was not the cause of the accident. Okay, so if you look at 274, very good, Ms. Collins. Thank you for staying with me.
Thank you.
Okay? On 274, 2/3 of the way down the page. It is fundamental that negligence is not actionable unless it is a cause and fact of the harm for which recovery is sought. It need not, of course, be the sole cause. And here is the language, and Ms. Collins picked it out. This is the language that you need to use in your essay. Right? Negligence is a cause and fact of the harm to another if it was a substantial factor in bringing about the harm. Right there. Right? Now, in these essays that 130 essays that I've been grading for the last week, right, I told y'all, right, assault is an intentional act causing a reasonable apprehension of imminent harmful or offensive contact to the person of the plaintiff, right? You wouldn't believe the number of variations on that sentence I have read, right? Use the definitions that I'm telling you that I want you to use, okay? I mean, you know, I've seen assault is the intent to cause imminent apprehension and a reasonable harm or offensive contact. I mean, we're mixing and matching words, right, that, you know, end up being nonsense. All right? You got to, I mean, it's sort of indicative that maybe some of us don't understand what we're talking about. It's not an imminent apprehension, it's a reasonable apprehension. Okay? And if you leave out, if you just say assault is the intent, right? What have you left out? The act, right? It's not just the intent, you got to have intent, you have to have an act, and you have to have causation. Right? So that's why I boil it down. Assault is an intentional act causing a reasonable apprehension of imminent harmful or offensive contact. If you say that, you said everything. You said all you need to say. Right? Also, I mean, we're going to talk about it some more next week when I give them back. If you have intent in your definition and you don't tell me what intent is, general or specific, then you've left out an essential part of the answer. Okay? So when I say negligence is a cause and fact of the harm to another, if it was a substantial factor in bringing about that harm, put that on a note card and memorize it. Don't paraphrase it. Don't even try. Just memorize it. Okay? Under the circumstances of the instant case, the excessive speed was undoubtedly a substantial factor in bringing about the collision if the collision would not have occurred without it. On the other hand, if the collision would have occurred irrespective of such negligence, then it was not a substantial factor. Okay? Here, irrespective of the 37 miles an hour, even had the train been going 25, the accident still would have occurred. Therefore, the negligence, the breach of the duty, was not a substantial factor. Yes?
If it had been a statute speed limit and the same accident happened, how could that be negligence if you wouldn't be able to stop at 25?
That's what I'm saying. It wouldn't have been. I'm just saying, I was just trying to make the point to recognize that if it had been a statute, we might have been able to frame this as a negligence per se. That was just backup material. You still would not have been successful. Okay? Because you still, if negligence per se negligence per se takes care of what for you? Right? If you're successful in pleading and proving it, what does it do for you? It takes care of the breach of duty, right? The statute establishes the standard of care, and the violation of the statute is the breach. What do you still have to have? Causation, right? So we still wouldn't have been successful in this instance. Yes, Ms. Johnson.
So how is it not relevant that how it's going to be a high speed that someone chose for 2 second prior to collision before it was
That's approximate cause issue, not actual cause issue. Okay, we'll talk about that next week. Good question. Third full paragraph, 275. On the facts of this case, we must reject the escape theory advanced in this argument because of the deficiencies in the evidence. That's another reason, Ms. Johnson, right? Which we have already noted, it is devoid of evidentiary support. The record contains no probative facts from which the court can draw a reasonable inference of causation under this theory. In essence, the argument is pure conjecture. That's another answer to your question right there, right? If it had been, assuming, that argument, the escape argument was what? Who's the plaintiff here? It's not the driver, it's the passenger. So the escape theory was put forth was, well, if it had been going slower, the passenger may have been able to exit the vehicle and get the hell out of the way before the train hit the car. Okay? But that's speculation. There's no evidence to support that theory, right? That's what the court saw anyway. I've got note 2 circled. Note 4, defendant excavates a hole in the sidewalk and leaves it unguarded and unlighted. Plaintiff, a traveler on the sidewalk, accidentally falls in the dark. Is defendant's negligence the cause of his injury? In that case, what's your answer? Yes. Okay. What if a third person negligently bumps into plaintiff and knocks him into the hole? It's still yes. Okay? However, suppose the third person intentionally shoves him into it. How would we frame that? Why is the defendant off the hook then, Mr. Siegel? Note 4, why is the defendant off the hook in the third instance? What's that? That's right. And the way we would say that, right, it interrupts the chain of cause and effect for the breach of the duty for leaving that hole in the sidewalk. The intentional battery, okay, because that's what it is, interrupts the chain of cause and effect from the negligence, the breach of the duty, and the causation of the injury. Okay, that's why the defendant is off the hook in the third instance.
Say that one more time.
The intentional act that is the shove interrupts the chain of causation between the breach of the duty that is leaving the hole in the sidewalk and the cause of the injury. That's right, and we'll get to that week after. We're going to talk more about that after next, at the end of the proximate cause chapter. Okay, that's exactly what you're right. It's an intervening cause. Note 5, the mate of defendant's steam trawler falls overboard and disappears immediately. Defendant's lifeboat is lashed to the deck instead of being suspended from davits and is equipped with only one oar. Is this negligence a cause of his death? No. Why? Why might that be?
Because he would have died anyway.
He might have died anyway, right? There are too many things that could have happened that would have continued to precipitate his death, right? And when you see this on fact patterns, okay, on multiple choice questions, right, what you will see is that, let's say, in a similar scenario, a boat is at sea and it's such a storm that the boat starts to sink, or the boat is overturned, and you will see it. It will say it in the fact pattern. That even, basically the storm was so bad, even had the lifeboats or the life preservers been available, everybody on the boat would have died anyway. Okay? And that's when, this is how that's tested. Okay? You'll see it. You'll know it when you see it. That even had the life preservers been available, everybody probably would have died anyway. I've got note 6 circled. And see, notice there in the middle of note 6. The evidence was that the horses were uncontrollable and could not have been stopped or directed. That even had the fence been constructed, the horses were probably going to go right through it anyway. Okay? And notice 8, the cause and the chain of cause and effect is interrupted. Right? If you can prove that the person wouldn't have read the instructions anyway, then the failure to warn will not support a cause of action. Okay? Reynolds, left side. Go ahead.
The facts of this case were, he was a passenger on Lee's train. The train was running late, so Lee's attendants told passengers to hurry. The plaintiff was a fat lady and fell down the unrailed stairs. He sued Dee in negligence. Dee argued that the accident could have happened even if the stairs were lit and railed.
Stand up for him.
Okay. The trial court ruled for P. LA Court of Appeals affirmed. The issue here is negligence a cause and effect of injury if it only enhances the chances of the injury? And the holding/rule of this is where negligence of the defendant greatly multiplies the chances of accident to the plaintiff and is of a character naturally leading to its occurrence. The mere possibility that it might have happened without the negligence is not sufficient to break the chain of cause and effect between the negligence and the injury.
Perfect. There it is. Right? That's exactly this passage I was going to point to, exactly the passage I would have read if she had not. Okay? And we're going to talk a lot about this week and next about the difference. What's the difference between a possibility and a probability, Mr. Walker?
Possibility is something that can happen. It may or may not happen. It can. Probability is
You got it? Come on.
Yeah.
You got it.
Yeah, what is probable is what I'm trying to say.
Right, it's more likely than not, right? Probability is a greater than 50% chance. Okay, it's more likely than not that something will occur. All right, and we're going to talk about that a lot over the course of the next couple of weeks. Similarly to the boat question, note 1 on 278, if a life preserver had been thrown to a drowning man, would he have caught it and been saved? There are too many ifs, right? If we had thrown it, if he had caught it, if it worked, if the water wasn't, if he hadn't gone into shock when he hit the water, there are too many ifs there that interrupt the chain of cause and effect. Okay? And these are difficult, as note 1 points out, these are difficult questions to answer, right? Okay, back to the right side. Gentry. Mr. Cruz, stand up for me.
Oh, yeah. So, Mr. Gentry's wife was at the ranch doing some decorating. Then Mr. Beacon was returning from the car with his gun to go hunting. He stumbled, shot her in the head. She passed away. He filed suit. The plaintiff claimed the ranch did not take care of the stairs, which caused the defendant to discharge his weapon. There was no proof that the stairs caused the man to trip. The rule is if the plaintiff fails to offer proof of duty, breach of duty, causation, and damages, then judgment for the defendant. Judgment was affirmed, and defendant won. Because they said basically that they failed to prove that that was
Right.
the reason.
The defendant here is,
Yeah.
I mean, you put, who's the defendant? It's not the guy who had the gun, it's the ranch, right?
Ranch, yes.
Right, and so they failed to argue, A, that, we'll call it dilapidation, right? Whether it was messy or whether the stairs were dilapidated, okay? They could not prove, because what did he say?
He said that
He was
he
pretty-
couldn't say what he tripped over.
He was pretty consistent, right? And do you believe him?
Yeah.
Why? Why do you believe him?
He has no dog in the fight.
Because he admitted.
Well, no, I mean, he had a dog in the fight the day the cops asked him.
Yeah, I'm sure he did.
Yeah, he did have a dog in the fight that day.
He admitted to being clumsy.
He admitted to being clumsy, and he also, but why do we believe him when he say he doesn't remember?
He said it several times, I think.
Yeah, he did say it several times, but why do we believe him? Because if I drop a weapon and it accidentally goes off and shoots a woman in the head, I'm going to freak out, right? What the hell just happened, right? So, I mean, I'm of the mind that I kind of believe him when he says it repeatedly. Man, I don't know what happened, and I'm clumsy, and things like I'm accident prone, right? But anyway, the point of the case is what? The plaintiff bears the burden of production and persuasion. In this instance, because of his testimony repeatedly that he didn't remember, right? We didn't have enough evidence to say that the condition of the building or the grounds surrounding the building were the cause and fact of the accident, or a substantial factor, right? That's how we say that. That the condition of the building or the condition of the grounds around the building were not a substantial factor in the accident because of the lack of evidence. Okay? Not to say that it might not have been the case, but we couldn't prove it. Right?
What if
Yes.
we put down the but-for test?
That's right. But for, right, or use it, I prefer, but for, we couldn't prove that but for the dilapidated condition of the building or the condition of the ground that the accident would have happened. Okay? But this is an evidentiary thing.
Will you repeat, you said substantial what? Substantial?
The substantial factor, right? And that's back to that quote from Reynolds.
Question.
Yes.
But earlier he had said in a deposition, he talked about tripping on those steps and
What page are you on, Vicki?
280
All right.
in the Q&A part. And I just wondered why, I mean, it wasn't, when they came back to him later, he said, I don't remember. But he did mention in this part that he had tripped on the steps before, and maybe it was the step. And
No, wait a minute. Look at the top now. You don't remember where you were?
You don't know.
No.
Before he got to the step.
He's affirming the first question at the top. And from the time after the rifle discharge, and you don't know exactly where you were when you fell or what caused you to fall. Is that right? Correct. Oh, and by the way, here's a practice pointer for everybody. Don't let your clients or don't let your witness, whether it be your witness or don't let your opposing witness, whether it's a direct or cross, say correct, because that's confusing, right? You have to make sure that when you're deposing somebody, you get a yes or a no. Not a yeah, not a head nod, not okay? It's a yes or a no. Not correct, yes. Is that a yes? Yes. If they don't do it, make them do it. Is that a no? No. Right? Is that a yes? You see what I meant? See where I'm getting at?
if he keeps going, in the interview with investigators, that's where he talks about falling on the step. Or maybe.
Well, see now, Vicki, that's not where you told me it was in the beginning. Now, where are we now?
No, it's just a few lines down. You started too high up on it. Just keep going. Just in response to Bacon's deposition testimony, which was cited, blah, blah, blah. So if you get into that part, so I'm just wondering why the interview with investigators was,
He said he don't remember if he tripped on the steps or before he got to the
see, I just think he's lying. I just read this and I think, you know, if you shoot somebody in the head, you damn well know what happened. I'm sorry, you just.
Okay, we disagree. The problem is, I mean, and so if this, so this is, and so whether the jury, if this goes to a jury, right? That's a jury question. The credibility of a witness is a jury question, right? Look at the inset on 281, the second one. Oh, wait, let's look at the first one. A suspicion, regardless of how particularized it may be, is not sufficient to sustain an action or to defeat a motion for summary judgment. Unsupported, conclusory, or speculative statements do not raise a genuine issue of material fact. And I've said this before, but genuine issue of material fact is the standard of summary judgment. Okay? If there is no genuine issue of material fact, then the court can direct a verdict for either the plaintiff or the defendant. Okay? The trial court has no duty to anticipate possible proof. Again, it's the plaintiff's burden.
Can you say that again? Genuine issue of material fact is?
The standard on summary judgment. Second inset, second paragraph. In an action for negligence, a plaintiff must produce evidence from which it can be reasonably inferred that negligent conduct on the part of the defendant or its agent was the proximate cause of the plaintiff's injuries. Here, the appellant simply does not know exactly what caused her injury. As noted above, the respondents cannot be the insurers of the appellant and held liable for her injury merely because an accident happened on their land. Good.
so because he declared bankruptcy, they just couldn't go after him at all. Was that
That you can't get blood from a stone. That's the point.
because he's walking with a loaded weapon, which right there is a violation of any kind of common sense. So,
Well,
I
then
don't
there
understand.
are an awful lot of people without any common sense. He didn't have the safety on, right?
I mean, it was loaded. If it hadn't been loaded, but for it being loaded, he couldn't have shot her in the head.
But for the safety not being on. You're not a gun rights activist, are you, Vicki?
No, I just read my permit.
What? What was that?
I just renewed my carry permit. No,
Oh, well, good for you. I've got no 4 circled. Notice, even though we must draw all legitimate, this is the parenthetical, even though we must draw all legitimate inferences in the plaintiff's favor, the inference that she was standing between the strips at the time of the accident because her feet could possibly fit between the strips is not an appropriate inference to be drawn. The possibility of the existence of an event does not tend to prove its probability. Right? The possibility of the existence of an event does not tend to prove its probability. You want this one?
No, I just have a question. I mean, I'll take it if you want me to. For note 4.
Note 4.
So I know you were saying that it would be, so between probability and possibility, so just say she was someone with uncommonly small feet. That would fall under possibility.
Right.
Everybody doesn't have.
Yeah, just the fact that her feet might have been between the strips at the time of the accident does not mean that
Well, I was just thinking.
it was the fact that the strips too far apart was the cause of the accident. Yes.
And so would the court look at it, they took steps to prevent it by having strips down versus no strips at all?
Oh, sure. I mean, I think that's looking at it from the other side, right? I mean, really what that note is about is just the fact that she was trying to prove that the boat was negligent by saying, well, I've got small feet, and those strips were ineffective because I have small feet. They didn't prepare for the size of my feet, right? That's not enough to say that it was because they didn't put them closer together that was the cause of the injury. Okay. Kramer, go ahead, BJ.
This was a case where the defendant.
Stand up for me.
Okay. The defendant was a guest. The plaintiff was a guest at the defendant's hotel. He basically opened a door and a piece of glass going in his foot.
From a what? Piece of glass from what?
From the
No, hang on. No blur.
Oh, a transom?
What's a transom?
I don't know.
You remember the old buildings? They had the glass. They had a glass panel, it was like a window above the door that they could crack it for circulation, for ventilation. That's a transom. You're too young. That's why I was just, yeah. And you just glanced, you looked right over that word and didn't look it up, didn't think anything about it.
Usually I don't know that. And I don't know why.
I'm just kidding. I'm kidding.
Yeah, because usually I really will look up the word that I don't know.
I hear you. Well, anyway, go ahead.
So it cut his foot.
Cut his head.
Cut his head. I'm sorry. I'm thinking about my situation, so I thought about the foot because I cut my foot. Anyway, it didn't heal for 2 years. He went to the first doctor. The first doctor didn't diagnose him. I'm getting it mixed up with lung cancer. The first doctor, he only went to one doctor. He was diagnosed with skin cancer.
At that spot.
Yes. And he tried to sue the hotel saying that the cut caused his skin cancer.
That's right. So he's trying to pin the skin cancer on the hotel owner, right?
And the trial court basically said,
We got two experts, right? First expert says what?
He said that there is a possibility that the cut caused the cancer, but it is a low possibility.
Right. Maybe 1 in 100.
Yes.
Second expert said what?
He said that there's no way.
There's no connection whatsoever.
That it would cause cancer.
If the plaintiffs hired these experts, they should have thought twice about it. Okay, right? Okay. So, what's the point?
basically it is not enough that the negligence of one person injury to another coexisted, but the injury must have been caused by the negligence.
That's right. Okay, so look at, thank you, BJ. Look at the bottom of 282, last paragraph. There is one heresy. Somebody read that as hearsay the other day. It was funny. There is one heresy in the judicial form which appears to be hydra-headed. What's hydra-headed mean? What is the hydra? What is the hydra? It's a Greek mythological creature. It had 9 heads. You cut one off, 2 grew back. And although cut off again and again has the characteristic of an endless renewal, that heresy is that proof that a past event possibly happened or that a certain result was possibly caused by a past event is sufficient in probative force to take the question to a jury. Okay, such was never the law in this state, and we are in accord with almost all of the other common law states. It is not enough that negligence of one person and injury to another coexisted, but the injury must have been caused by the negligence. Post hoc ergo propter hoc, what does that mean, Mr. Russell? No? Huh? Harwood's trying to show off back there. I'm not going to let him. That's right. After this, therefore, because of this. Right? Very good. Post hoc ergo propter hoc is not sound as evidence or argument, nor is it sufficient for a plaintiff seeking recovery for alleged negligence by another toward the plaintiff to show a possibility that the injury complained of was caused by negligence. Possibilities will not sustain a verdict. It must have a better foundation. Okay, all right, that leads to this. What is our burden of proof in a civil case, Ms. Leith? No, I mean, what's our standard of proof, Mr. Kellum?
Preponderance of the evidence.
Preponderance of the evidence, okay? We must prove our case to the jury in a civil case by a preponderance, generally most of them, by a preponderance of the evidence, which means, Mr. Kellum, means what?
Say that again, sir. Sorry.
What does the preponderance of the evidence standard, what does that mean?
That means that you have to have ample weight to one side or the other.
It means more likely than not, right? It's a 51%. More likely than not, there's the probability that, in this case, the negligence was the cause of the injury. Okay, so again, that goes back to what we were talking about all day. Possibilities versus probabilities. Okay, does anybody know, what's the next step up? BJ? Nope, there's one in between. Anybody? What is the next step up in the proof burden? Clear and convincing evidence, right? And if I have to put clear and convincing evidence, if I have to quantify that, if I say that the preponderance of the evidence is 51%, in my view, and this is pretty subjective, clear and convincing would be 75%. Okay, it's a 75% likelihood that this was the cause of this. Okay, and then the next step up, as BJ pointed out, is beyond a reasonable doubt, and that applies solely to what? Criminal cases. We don't talk about it in here because it solely applies to criminal cases. There used to be a standard of evidence called a scintilla of evidence, which meant what? What does that sound like, Coach? It's any evidence whatsoever, any evidence at all. A scintilla, an iota of evidence was enough to go forward with a case. That is generally, I think we see it mentioned in one of these cases in the book, but we haven't seen it yet. But that evidentiary standard has pretty much gone the way of the dodo. I've got note 1 circle. In note 2, in the middle, the parenthetical from Wilder v. Eberhardt. Defendant's experts should have been permitted to testify because defendant need not prove another cause. All right, it's not enough. They don't have to prove that something else actually happened that was the cause and fact of the injury. Only persuade the trier of fact that the plaintiff's putative cause was not the probable cause. All right, they only have to prove that the plaintiff's putative cause was possible, not probable. Notice in note 3, what if plaintiff's proof shows 3 possible causes of a fireball shooting out of her oven? Wow. Okay. I don't know what that looks like, but it doesn't sound good. All of which can be traced to the manufacturer, but none of which is more likely than not. Then, in that case, you don't have to. The plaintiff would not have to prove exactly what happened to cause the fireball. All 3 causes go directly back to the defendant. Okay? No matter what happened, it had to be something the defendant did, so you don't have to prove the particular thing that happened that made the ball of fire emerge with force from the oven. Note 4, cases dealing with informed consent, right? And the different standards, right? We talked about that, whether some courts use a reasonable person standard, some courts demand that the plaintiff himself or herself would not have gone forward with the procedure had they been fully informed of the risks Okay? Y'all seem to be quiet today. What's up? Mr. Walker, you alright? It's cold. It's cold? You're always quiet. I'm not. Alright, Herskovitz. Listen, this loss of chance thing goes back to our possibility versus probabilities, right? What's the deal here? Right? Don't go through the whole. I mean, I'm going to say this, and I know it's not true. We've all read it, so we don't have to. Go ahead, Mr. Harwood.
First pick had a 50% chance of living from a lung cancer that wasn't diagnosed. He sued, or his estate sued, because, and there was a summary judgment in the doctor's favor. The family appealed, and the cause of action was reinstated.
Well, okay. It's gotta be. We got to have a little bit more than that. So, let him go. Let him fix it.
I'm still back to one of my 3 Latin phrases.
Oh, what, yeah. Oh, all right. We stumbled upon one of the 3 Latin phrases you actually know. Is that what you're saying? So, what's our deal here? We've got a guy with terminal cancer, right? Is he going to die? Yeah. No, he's going to die, right? We know he's going to die. What is the cause of action here, Mr. Golden?
The cause of action is they decreased his survivability chances.
Right, that he was going to, he might
Basically, he would die sooner.
Right.
Potentially die sooner.
But he is going to die.
Right.
Right?
So they robbed him of what
A
remained.
14% chance of living a little bit longer. Okay? What's our, do we see the problem with proof here? Do you see how hard this would be to establish? That, hey, if and convince a jury, there's some pretty good lawyering going on here. Okay? Because, they've established that, and the court's approving this, right? That had, the experts came in and said, if this diagnosis had been made earlier, then there's a 14% likelihood this guy may have lived X amount of time longer, right? And do you agree with that, Ms. Johnson? Is it a month? Is it 3 months? Is it 8 months? 3 years? Because why is this? Why are we concerned here? We've got to put some kind of time limit on it, right? Why?
Preponderance.
What's that?
Preponderance.
No. We got to put a time limit because why? Damages. At some point, we've got to go to the jury and say, here's the box, and I think the plaintiff's attorney is going to say, jury, you should award X amount of dollars. And the court even says it that when the court remands the case back to the trial court, we're only going to give them the damages for loss of what? Loss of possible income that he might have made had he lived longer. So we got to have a time window, right, in order to quantify the damages. Is that even possible? Right? You see what I mean? And so now what happens? What do you have? You got to have experts, right? And the plaintiff's experts are going to say, well, if they had done this, he had a 14% more likely chance of living, for 18 months. And if the jury buys that, what do? You do the math. How much money would the man have made had he been able to work for 18 months? Even if he had lived, would he have been able to work for those full 18 months, or would he have been, incapacitated after 12? All right? These are tricky problems. And I'm not sure that even as a plaintiff's attorney, I go, right?
But wouldn't the goal be here basically just to get it to the jury?
Yes.
Play on their emotions?
That's right, exactly. You get it to a jury, you play on their emotions. This poor woman lost her husband, she could have had him for another 8 months. And, et cetera, et cetera. Main issue, down at the bottom of 285. The main issue we will address in this opinion is whether a patient with less than a 50% chance of survival, okay, it is probable he is going to die, as a cause of action against the hospital and its employees if they are negligent in diagnosing a lung cancer, which reduces his chances of survival by 14%. And then back to my point from earlier, top of 287, causing reduction of the opportunity to recover loss of chance by one's negligence, however, does not necessitate a total recovery against the negligent party for all damages. In other words, it's not an action in wrongful death, right? All damages would be they were responsible for his death, and obviously that is not the case. They did not give him the cancer, okay? Caused by the victim's death, damages should be awarded to the injured party or his family based only on damages caused directly by premature death, such as lost earnings and additional medical expenses, etc. Now, let me say this. That seems like it's kind of esoteric. Are you so cold you have to leave? Oh, okay. I'm just joking with you. Miss Dudley picked up her coat and going home. I don't know what No, let me see if I can turn it down. I did not fix that latch, no. Well, it's probably J.H. Berry. But this seems, what my point is, this seems esoteric, right? But I have seen it crop up on sample bar questions, okay? So I'm not necessarily going to test you on this, but don't forget about it when you're preparing 3 years from now, okay?
It would have been 5% instead of 14%. I mean, where do you draw the line?
I mean, I'm telling you, this is really arbitrary. I see your problem with it. I mean, I really do. I don't necessarily agree with it.
I'm not going to talk about damages so we can figure out if the 14% is equal.
Well, it's worth something, right?
I mean,
It's not. What I think my point is that not maybe we can.
I mean, because as an attorney, you're not going to take it unless you see that there is money. So that's the damages.
14% of me
I'm sorry. What did you say, Miss Will? I'm sorry. I looked down and was reading. I was reading the paragraph. What did you say? That's right. That's right. That's right. Right. I'm not sold.
So we're going to learn about damages, right?
Oh yeah, we're gonna learn about damages. We're gonna learn about damages.
Because that's what that would be the only reason you take it, what you're saying is to hope that the jury can punish somebody who gets convicted.
That's right.
I'm just saying,
Yeah,
it ended up being 14% that we're sitting here mulling over.
Well, let it alone.
All right, we're in the rabbit hole. We're in the rabbit hole.
All right, leave it alone.
Got a very important date. Look at note 2. Other jurisdictions have analyzed the issue by viewing the patient's injury as the loss of the opportunity for a better outcome rather than as death or worse outcome. In those jurisdictions, the patient is permitted to recover damages, but only a proportion of the full amount. Loss of chance to avoid fatal stroke attributed to defendant's negligence. Now, look at the second parenthetical. Loss of opportunity for a substantially better outcome because defendant's misdiagnosed spinal cord injury. Now, see, there is a better sort of factual scenario, right? Why? because he's not dead, right? Because he's not terminal, right? If you're in an accident, you know, if one is in an accident and one goes to the hospital and, you know, well, let's see, let's simplify it a little bit. You know, let's say you're having a stroke, right? And you don't feel well and you don't know it's a stroke, but you go to the emergency room and they don't realize it's a stroke either, and they should have. Okay? And they always say time is of the essence, right? When someone is having a stroke, right? And so whatever brain damage happens after the misdiagnosis and the plaintiff lives, okay, now you've got a better quality, the loss of the chance of a better outcome. Had they picked that stroke out when you walked in the door, you would have been substantially better off in recovery. Okay, that's a better chance. Now that I like that cause of action as opposed to the primary case. I like.
Well, I mean, not that you don't want to help somebody, but you can't put all those expenses unless you want to get
Oh, that's right. But my point is, in that case, there is going to be a bigger recovery, right? I've got 3 circled as well. Look at note 6, attorney malpractice cases. Okay, we talked about this, right? The thing about attorney malpractice cases, if one sues you or sues an attorney for malpractice after having lost a case, look in the middle of this here. Noting that a majority of jurisdictions require plaintiff to prove 1, that he would have won, 2, how much the award would have been, and 3, that the award was collectible. Okay? And then the defendant attorney can affirmatively plead that, well, even had we could plead and prove, even had we done everything right and we had won, we weren't getting any money out of it anyway. Okay?
Dean,
Yes?
does that fall under if you, like as an attorney, if you write down a case wrong on the wrong day or at the wrong time and you miss the trial and the trial moves forward without you, and you lose?
Yes.
Okay.
If you fail to show up, yes. Generally, though, if one of the parties' lawyers is not there, the court will, however begrudgingly, postpone the proceedings, right?
Or at least try to call.
Joining the majority of jurisdictions, 7-2, parenthetical, joining the majority of jurisdictions that require plaintiff show that he is actually innocent of the underlying criminal offense. And I like the discussion of negotiation, proof of causation in a negotiating context on 290 in the large paragraph in note 8. Down toward the end of the quote, every point within the range bounded by the lowest offer that one party will accept and the highest offer that the other party will make is a possible transaction or settlement point, and none of these points is correct or incorrect. That was in note 8 on 290. Just before the cite to Nicolette Instrument Corp. v. Lindquist. Okay, Dalbert, say it, tomato. Okay, you will see, hang on, you are going to see this case in your evidence class as it pertains to Federal Rule of Civil Procedure 702. Okay, but this case is the same case, but this is the disposition on remand back to the Ninth Circuit. Ms. King, go ahead.
Okay, so the facts.
Stand up, please.
Okay, so the facts were that the minors were born with birth defects due to the mold ingestion of drugs that were manufactured by the factory. So they said that the product caused birth defects to the baby. So the court concluded that the 8 scientific experts that the plaintiff had brought forth that would cause the birth defects were based on scientific techniques that were not generally accepted in the scientific community.
That's right. Now that's important language, right? That's good. Go ahead.
Okay, so the issue that I said was that is if the expert testimony offered by the plaintiff was admissible. So the rule is that testimony from a qualified expert is admissible if it will assist the jury in comprehending the evidence and determining the fact. They must show the research conclusion was reached after the scientific for various scientific methods of research. So the whole thing that I said was Rule 702 was the rule for admitting expert testimony. Under Rule 702, the plaintiff must show that the evidence they offer would assist in determining a factual issue. So since the court focused only on general acceptance tests, the decision of the U.S. Court of Appeals was vacated and case remanded because the expert's research was not independent of litigation and the theories had not been published in scientific journals or reviewed by peers. So basically, it was just all Rule 702. It was like certain tests that they had to do and they did. So that's why they.
Okay. So right. All right. Good. What was the issue that was taken to the Supreme Court? Don't sit down. I'm finished. That's your question. What was the issue that was on appeal to the Supreme Court?
Is if it could be accepted or not. Those testimonies could be accepted.
No, you said it earlier. Say it.
Oh, okay. Well, is it the expert?
What had the trial court done that was a point of contention? Why was it on appeal to begin with?
Because if it was generally accepted.
No. It's even simpler than what you're trying to say, right? It was whether the expert's testimony was admissible.
Oh, yeah.
Okay? So, what is the standard for the admissibility of expert testimony? That's what. So, the plaintiff here said, I want to present these experts. And so, when you go, I got it. Thank you. So, when you start getting into these expert testimony, right, you'll hear, and you guys will learn this. Those of you who work in law offices might already have heard it. It's a Daubert challenge, right? Like, if I'm going to property, these experts, some of them are a little iffy, right? And one point that Ms. King pointed out, one thing about these guys these people that were being put forth by the plaintiffs here, one thing about them was what? All the opinions that they had put forth were derived from research they had done in anticipation of participating in this action. Okay? Which causes what? It sheds, it casts a shadow on the veracity of what they're trying to say. Now, you will see there are guys, the folks out there that are career experts. And they've got CVs that are, half an inch thick, right? And they publish all this, and they have to list all these things that they've written, and list everything that they've done. Some of them are dubious, right? And so the opposing counsel will issue what is called a Daubert challenge that questions the qualifications and the opinions proffered by the opposing expert. And it questions whether that expert's testimony should be admissible to present to the jury in a case. Now, in that big Blue Cross Blue Shield case that I was involved in, that's still going on, okay, the plaintiffs in that case, we were trying to prove damages across a wide geographical area, right, that Blue Cross and Blue Shield, through the Blue Cross and Blue Shield Association, was violating the Sherman Act. Okay, and so we had world-class experts, economists, right, working on this thing, and you should see the bills. All right? It was crazy how much I missed my calling. I should have stuck with economics. Oh my God. I mean, these people, they're billing us. It was crazy. Well, how are we going to pay for this? To your point, Ms. Willis. And we haven't yet. Or they haven't. I'm not involved anymore. Thank God. Okay? But those folks, those types of folks are unassailable. If you're going to go after somebody like that, you can't go after the person, you got to go after the methodology. Right? And you've got to have an expert that says, this world-class economist's opinion in this matter is wrong, and here's why. And you basically have to prove it. That's called the battle of the experts, right? And it can go on and on and on. Some of the most entertaining deposition testimony you will ever read, and I hope it happens to all of you at one point, is some lawyer trying to get under the skin of one of these world-class experts. And the expert's not having any of it. It is awesome. Right? It is funny. That's not what I said. Well, you said right here. That's not what I said, sir. And they'll just go at it for hours. The other thing is, right, now some of the most boring testimony you'll ever see is when they get the expert on the stand. Right? With the other expert. Huh?
Classes first.
Oh, yeah. Oh, absolutely. I mean, they're expensive. But don't let and as a practice pointer, don't let experts push you around either, right? Don't let them do it. So, admissibility of expert testimony. The court is used in here. So if you look at top 292, okay, the old standard was the Fry standard. Okay, it was just until recently that Alabama still maintained the Fry standard. Imagine that. Okay. At the very top, 292, scientific evidence was admissible if it was based on a scientific technique generally accepted as reliable within the scientific community. So when this case goes up to the Supreme Court says, nope, we're going to change the rules. Okay? And then we have a two-part test under Brave New World there on 292. Under Daubert, we must first engage in difficult two-part analysis. First, we must determine nothing less than what the expert's testimony reflects scientific knowledge, whether their findings are derived by the scientific method, and whether their work product amounts to good science. In other words, the court has to make a determination as to the, again, veracity or the of the science, whether it is good science. And obviously, the court is trepidatious here. The court doesn't necessarily feel well equipped to make that determination, right? Because back to the Blue Cross Blue Shield case and all this complicated economics, Judge Proctor said, it was 2 years ago, I remember the date. He goes, January the 21st, 2017, we're having Education Day. And everybody's going to bring their experts, and they're going to teach me what they're talking about. And he had the big courtroom at the top of the Hugo Black building, and they did. All these brainiacs came to town. There were like 8 of them. And Judge Proctor sat up there and tell me what the hell it is y'all do. Right? You're gonna teach me, you're gonna make me comfortable with what you're trying to tell me in this case. And it was complicated. So you can see, you can read the tone in the court's opinion here, this is hard for us to do. We've got to determine whether this is good science. Because at the end of the day, it was Judge Proctor's. It's going to be Judge Proctor who's going to say, this guy's right and this guy's wrong. Okay? That's why we love our judges. Second, we must ensure that the proposed expert testimony is relevant to the task at hand, that it fits what the issue in the case is about. Okay? And it's got to be on point, the fit test. And so you see the language here, right? The court is the gatekeeper. Okay? The court is the gatekeeper of what is admissible and what will assist the trier of fact in understanding the issue and who is responsible for what. Okay? And again, you're going to read you'll see the Supreme Court case in your evidence book next year. Oh, the language we got here. Yeah, there it is in the middle of 293. Federal Rule Evidence 702. Whether the theory or technique employed by the expert is generally accepted in the scientific community, whether it's been subjected to peer review and publication, whether it can be and has been tested, and whether the known or potential rate of error is acceptable. The margin of error. All right. Yeah, we got any statisticians out there? In here? Anybody? No? Look at 294, second full paragraph. But the test under Daubert is not the correctness of the expert's conclusions, but the soundness of its methodology. That the research is accepted for publication in a reputable scientific journal after being subjected to the usual rigors of peer review is a significant indication that it is taken seriously by other scientists. In other words, that it meets at least the minimal criteria of quote-unquote good science, which is the term the court was concerned with on first page of the case. Look at note 9 down there at the bottom, last sentence. That plaintiff's experts have been unable or unwilling to publish their work undermines plaintiff's claim that the findings these experts proffer are, quote, grounded in the methods and procedures of science and, quote, derived by the scientific method. Bottom of 295, last full. Modern tort law, halfway down. Modern tort law permits such proof, but plaintiffs must nevertheless carry their traditional burden. They must prove that their injuries were the result of the accused cause and not some independent factor. In the case of birth defects, carrying this burden is made more difficult because we know that some defects, including limb reduction defects, occur even when expectant mothers do not take Bendectin, and that most birth defects occur for no known reason at all. California tort law requires plaintiffs to show not merely that Bendectin increased the likelihood of injury, but that it more likely than not caused their injuries. That it was probable that the drug caused the injuries, or was a substantial factor in the injuries coming about. Why are we talking about California tort law in the Ninth Circuit? Anybody? Ms. Harding? Why are we talking about California tort law in the Ninth Circuit? No, didn't you take my conflict class? Then why are we talking about California tort law in a federal court?
Because the Ninth Circuit covers California and because of the Erie rules.
That's right, because of the Erie rule, it says what?
State law governs federal court.
A federal court sitting in diversity must apply the substantive law of the state in which it sits. There it is, right there. Very good. Bonus point, Mr. Benson.
Thank you, contracts class last week.
Look at note 3 on 297. Second paragraph of the inset. The issue is the reliability of his opinion from a legal perspective, and what science treats as a useful but untested hypothesis, the law should generally treat as inadmissible speculation. In other words, if you cannot prove it, then it is not admissible, or at least prove that it is more likely than not. If the methodology is unsound, then it is speculative and will not be admitted. Next paragraph in the middle again. But the alternative route, allowing the law to get ahead of science, would be just as unfair. Such an approach would destroy jobs and stifle innovation unnecessarily. Okay? That's a rabbit hole. was just about to say the words big pharma. I'm not doing it. Never mind. Note 4, 298. Does the court's gatekeeper function apply only to novel scientific theories? No. You will see cum ho tire in your evidence class as well. I've got note 7 circled and note 9. Notice on note 9, generally a plaintiff in a tort case must establish causation by a preponderance of the evidence. We talked about that earlier. In claims made in no-fault systems like workers' comp, or in proceedings setting governmental safety standards, however, the burden of establishing causation may be lower than the preponderance of the evidence. And that is a reasonable probability standard. And that militates against everything I've said earlier today. What happens in the Hill? Pleasure? You got this one?
In this case, the plaintiff was injured. He was a passenger in a car. He was injured. The car collided with the truck that was parked in the middle of the street. The defendant owned the truck, and he had left the truck in the middle of the road at night without the lights on. And the person driving the car said that he saw the truck in front of her right before the accident, and that it's possible that it was her fault. And in general, that statement caused the court to dismiss the case against the defendant. The plaintiff sued the defendant for negligence. The court dismissed the case based on the testimony given by the driver of the car admitting fault. The plaintiff appealed that. The issue I have here, are the driver of the car carrying the passenger or the owner of the truck both negligent for the plaintiff's injury? Either or are both negligent for the plaintiff's injury. Rule: when two separate acts of negligence produce a single harm, each tortfeasor is wholly responsible for the harm, even though his act alone may not have caused it. Holding was reversed, and the reason for the reversal was because both the owner of the truck and the driver of the car contributed to the plaintiff's injury. Right.
So at the trial court level, the court concluded that the driver of the car was negligent and had dismissed the guy who left the truck in the middle of the street, right? And so that was error. It's important to note here, read that sentence again about the entire result.
Entire result? I mean, the rule were two separate
Yeah, the rule.
acts. Okay. When two separate acts of negligence produce a single harm, each tortfeasor is wholly responsible for the harm, even though his act alone may not have caused it.
Okay, that's right. Even though his act alone might not have caused it, we have two breaches of two separate duties, and we have a single injury. All right. Each tortfeasor here, thank you. Each tortfeasor here, having breached their duty, okay, is liable. And here, that's the kicker, for the whole thing. And we're going to talk about joint and several liability, okay? But that means each tortfeasor, like if we got a judgment for $10,000, okay, and we have two tortfeasors, two guilty defendants, okay, we can go after one of them. Each of them is responsible for the entire result. So one has money, one doesn't. We go after one. We get the money from the one who has the money, and then that defendant can go work it out with the other defendant for what we call a contribution. Okay, but we'll get to that in damages. But we see this, right? We got one injury, we got two tortfeasors, both are fully liable for the entire injury. We're not apportioning liability here yet, okay?
you know what the outcome is like, just out of curiosity, you know? Once the new trial was ordered, you know what the verdict, what the outcome was?
No, I don't know.
I'm not really clear on why the driver of the car was equally at fault. I mean, somebody parks,
It doesn't matter.
it doesn't matter that.
It does not matter. In this context, that does not matter. We have a breach of duty that has caused an injury. It does not matter if it was 75% or 25%. In the joint and several liability world, it does not matter. Now, in the comparative negligence world, when we get to that, it does matter, right? We can, in comparative negligence, we can say we've got a $10,000 verdict. The plaintiff herself, okay, that's not the case here. The plaintiff herself is 30% at fault, which reduces the plaintiff's recovery by $3,000. I mean. So now we got $7,000 left. In your scenario, if it's determined that the driver of the car was 20% at fault, okay, then the driver of the car is responsible for $2,000, and the other 50% would be the guy that left it in the truck, left the truck in the road, left it in the truck. See what I mean? In the comparative negligence world, that's how that works, but that's not where we are right now. Okay, got me? You're looking at me.
I'm just thinking, if I'm driving home tonight and somebody parks a truck in the middle of the street and it's stormy, and all of a sudden I hit it,
But
that's my fault too?
Yeah, if you're driving 85 miles an hour,
Well, it doesn't say that she was speeding, does it?
it says that she was negligent. It was determined by the court she was negligent.
She was probably texting.
She might have been texting
65.
in 1966. She might have been drunk.
So, I don't understand what you mean about joint several liability, but it doesn't matter what the percentage is. They're both equally responsible.
That's right. In this world. In this point where we are right now.
But prior to negligence, we just haven't gotten to it.
We haven't got.
And that's where it would be.
Comparative negligence. Go ahead.
But I guess I'm saying, how would you know, we just have to take it at face value that they're telling us that they're both responsible.
That's right.
Because how are we going to know when we see a fact pattern, which one?
Oh, that's a good question. Say it louder. How do you know it's a comparative negligence jurisdiction and a fact pattern?
Yes.
The default, I'll go ahead and tell you this. There are three different kinds of comparative negligence jurisdictions, right? And we're going to get to this. Don't write this down. Don't worry about it now. But what Dr. Friend is asking about, how do you know you're in a comparative negligence jurisdiction? Either you're told where you are, or if you're not told, you are the default is you're in a pure comparative negligence jurisdiction. If you're not told, you're for bar purposes, you are to assume you're in a pure comparative negligence jurisdiction.
And then they told us here by telling us that both were jointly, they said it. Fact finders said it, that's how we knew that it was joint and several liability in this case.
Right.
Thank you.
All right, Anderson. What you take from here on 301 is toward the end. If a fire set by the engine of one railroad company unites with a fire set by the engine of another company, there is joint and several liability, even though either fire would have destroyed plaintiff's property. Okay? Even if one alone would have done it, if it joins with another, both are responsible. I've got note 1 circled. The answer to note 1 is both. I've got 4, 5, and 6 circled. That's esoteric information, jurisdictional specific information. It's interesting to talk about, but it's not testable because it's jurisdiction specific. Look at note 5. California has clarified the use of the but-for test and substantial factor test in its jury instructions, noting that the but-for test remains operable for all negligence cases except those involving concurrent independent causes where the substantial factor test should be used. What do we mean by concurrent independent causes? Two things independent of one another happen at the same time, resulting in an injury. Okay, then you go to the substantial factor test in California at least. Two things happen at the same time, independently of one another, resulting in a single injury. And so in California, the substantial factor test, instead of the but-for test, which is more specific, right, kicks in.
Where was that?
Hmm?
Page, where was that?
That's me talking. That's note. I'm talking about note 5 on 302. All right, the next one's a big one. Ms. Felton, you got this one? Summers v. Tice?
Plaintiff and defendants were hunting. We both shot at a wheel, and one of them hit Clayton in the eye, but no one knew which actually shot the plaintiff.
Right.
The court found for both, against both. If two defendants shoot at a plaintiff, only one hits without knowing, both are liable. Where both were acting negligently, but one is liable, the burden of proof shifts to the defendant.
There you go. That's big, right?
Yes. Both are liable and judgment affirmed.
Okay, so, all right, good. So, why is it that we don't know? Why is it that we don't know which one of the two shot the guy? Right. Those little pellets are forensically unidentifiable, right? So, do we see why the burden shift? Why does the burden shift? Ms. Felton? All right, let her think about it. Because, well, wait a minute now. It's on the plaintiff, right? Let's say it again. It's on the plaintiff. The burden of production, the burden of persuasion is on the plaintiff, right? If the plaintiff can't, we know somebody screwed up, right? They both fired at the same time, but we can't prove which one fired the pellet that ended up in the eye, right? So if it's on the plaintiff to prove who did it, and it's impossible for the plaintiff to do that, if we don't shift the burden to the defendant, what happens?
I was going to say that defendant could prove that he wasn't at fault.
That's right. But if we don't have this, what happens? We have an injury. We have a remediless plaintiff, right? And so we have in order. That's not fair, right? So we shift the burden to the defendant and say, okay, guys, if one of you can prove that you're the one that didn't fire that, then that's how you're off the. That's the only way you're going to get off the hook. Otherwise, both of you are responsible, jointly and severally liable for the entire harm, which is the injury to the eye. Yes, sir.
If not, each one of them be able to show up and just say, it was the other guy.
That's right. That's exactly right. The plaintiff, it was him, I didn't do it, and that's what they're going to say anyway, right? This is called alternative liability, okay? You'll see the term, you might see the term on the bar exams called alternative liability, okay?
So that means anytime the burden of proof shifts to the defendant, that's alternative liability?
No, in case of concurrent tort fees, that's alternative. Not any time. Okay? Look at third full paragraph. Well, call it second full, the part with the italics. The court then stated, quote, "We think that each is liable for the resulting injury to the boy, although no one can say who actually shot him. To hold otherwise would be to exonerate both from liability, although each was negligent, and the injury resulted from such negligence." Next paragraph. When we consider the relative position of the parties and the results that would flow if plaintiff was required to pin the injury on one of the defendants only, a requirement that the burden of proof on that subject be shifted to defendants becomes manifest. They are both wrongdoers, both negligent toward plaintiff. They brought about a situation where the negligence of one of them injured the plaintiff. Hence, it should rest with them each to absolve himself if he can. Okay? And we see this again, right, in other contexts. Remember, we talked about when, when the sponges get left in the, in the surgical spot, right, or the clamp gets left in the abdomen, and there are 7 different people in the room at the time, any one of whom might have left that clamp or been responsible for it. But what's the matter? Our plaintiff can't prove who did it. Why? Let's say this before cameras and everything. Why? Because he was unconscious as the thing was going on. So if the plaintiff can't prove which one of them did it, he would be left without a remedy. So it's up to whoever was in that room to say, it wasn't me, and I know who did it. And this is why it happened. And I can prove it. Okay? But that one case, that Summers v. Tice, emanates throughout tort law, okay? And you can see it, even a case as complex as the enterprise liability and market share liability cases. Sindel refers directly back to something as simple as 2 guys on a quail hunt, okay? Now, we talked about loss of chance being a little bit esoteric. This market share liability is kind of the same thing, right? It does come up on the bar exam, so you can't gloss over it. But it's complex, and so I tend to preach about it instead of letting y'all brief it. But somebody give me the bare bones facts. Go ahead.
Female's mother prescription drugs during while she was pregnant for a miscarriage. And there were 5 manufacturers of this drug. Some of the pharmacies didn't keep up with what manufacturer shipped when. Later on, that was proven that the drug caused cancer in the reproductive organs of the children. And she got cancer.
Right. Okay. And well, we didn't have We don't have 5 or 6, we have 5 or 6 primary manufacturers, but there were really how many? There were really over like 195, right? That might have, that did at one point market this DES substance, drug. Okay? And so here we have an injury, right? Somebody, and we had a stand, it was one recipe, right? We had 195 cooks, one recipe. And so what are the defendants arguing? The defendants arguing that, well, if it's on the plaintiff to prove that I'm the one that caused her injury, then she's got, that's the traditional standard, right? The plaintiff has to prove which defendant caused the injury. Well, the court says, well, we've got to get creative here, otherwise we've got a whole class of people who will be left remediless again, okay, because they can't prove exactly which manufacturer of this drug the mother took, right? And so the court says, well, the court says a few things. By the way, I've got 2 and 3 circled on 305. I jumped ahead.
In a situation like that, why wouldn't they, I'm just trying to learn, why wouldn't they just go ahead and bring a class action lawsuit or something like that?
Oh, this is a class action.
Okay.
Okay. This is the personal representative, okay, of the class. Okay. Now, that's a good point, and to sort of, you've got certain elements, you've got certain requirements you got to have a class action. You got to have commonality of injury, typicality of injury, numerosity, which means you got to have enough people that it would be impracticable to join all of the plaintiffs in an action, and you got to have adequacy of representation. And there's some other things that come in at 20. That's Rule 23A, and then there are some other factors that come in and the types of class actions there are in Rule 23B. Here. And you all see the advertisements, right? For, whether it's the hernia mesh or the mesothelioma or, all these things that have gone on for the last several years. There's a distinction between a class action, because in a class action you got to have similarity of injury, right? You got to have the same injury that happened to a lot of people, and here it would probably revolve around a specific birth defects, right, of a similar type, where the injury is sort of in a narrow range, right? Huh? Limbs, yeah, limb loss. Okay, what the difference between a class action and a mass tort, okay, is that you have. I was involved in a mass tort action that involved pacemaker leads. Okay, Medtronic had made pacemaker leads. They put out on the market faulty pacemaker leads, which is a little piece of wire, right, that made the charge in the pacemaker go bump, 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 right? Well, what would happen sometimes with these faulty leads is that it would go off when it wasn't needed. It was basically like an internal taser, okay? And so there were, we had people that handled it well, right? We had plaintiffs that handled it well, so they experienced a lot of discomfort, and there was, depending on how many times it happened before they got fixed, and that was in one bucket, right? And then we had people that had more serious problems because of it, and we put them in, so they were in this bucket. It was all in one action. And then there were folks that had passed away because of it, and so obviously those injuries were more severe. And it was up to the court to determine which bucket to put each person in, and therefore how much they would recover based on the severity of their injury. Okay, so the difference in the injury is what keeps that as a mass tort, right? In a mass tort, you have each individual plaintiff is still named, right? In a class action, you have one personal representative that adequately represents the interests of all the class because of the narrow similarity in the injury. You see what I mean? That was a lot, I'm sorry.
Can I ask
Yep.
How do they title the mass torts where there's not one representative? How are those?
No, what happens is you've got several different people going to the same court to file a different action in each, right? And so, okay?
Eventually they get into the same court.
Right, and in the case of the lead case, it's like the district, the District of Minnesota was handling that lead case.
So when do you go to MDL?
Hmm.
Would you go to multi-district?
Yeah.
When do you do what?
Okay, go to the multi-district litigation. There's a separate arm of the federal judiciary that handles multi-district litigation. But that's all zip pro. We're off the rails. Okay. So here, what the court does says, is it reasonable to say that if 5 of the named defendants here produce 90% of the DES in the market, and let's say in California, it is determinable within a reasonable amount of error, okay, that it's 20% likely that the woman bought a product from Abbott Labs. It's 30% likely that she bought a product from Johnson & Johnson. And so, in order to avoid leaving the plaintiff without a remedy, we're going to call it market share liability. And who do we call? We call in those world-class experts that I was talking about earlier, and we do a mountain of electronic discovery, and we come up with a figure that says at this point in time, notice also that we're a generation away. So we're talking about, 20 years ago, who had the 20% of the market in California for the sale of DES? And unless one of those defendants can prove that we weren't in the market in California at that time, then they're responsible for 20% of the injuries and 30% of the injuries, depending upon the share of the market at the time. All right. Again, that's complicated. I'm not going to give you a essay question on that, but it does come up. You can't overlook it. Okay? You can't overlook it. Joint several liability, though, is very important. Summers v. Tice is extremely important. Score time.
24-28, Auburn has 58 seconds left to go. Good God, please.
Who's got the ball?
Texas A&M.
I got 24.
It's third and second, yeah.
It's third and second. A little nervous there, are you, Rolanda?
Yes.
Oh, I just realized it.
Football.
All right, note 2 on 309.
Third and second for base.
And note 9 on 311. Okay? Listen, we're in good shape, okay? We're in good shape. We're going to finish up just right. We've got next week and the week after, right? Then y'all get a nice Thanksgiving break. Break. It is a break. What's that? What's up?
So is everything being pushed back a week? I'm confused. We're not doing the.
We're not going into proximate cause is too much to do today. So it's heady. We're going to go into that next week, and then probably what we'll do is combine it and get into intervening causes next week, and then finish intervening causes and joint tort feasors the week after that, and then have the review, which is basically a recitation of the table of contents.
So we've done review for this class on the first.
What's that?
We've done review for this class on the first. When we done with this class.
The second half of The 17th.
It's a left.
The last day of class. And then you've got 3 whole weeks to study. And I say that all the time, right? Good thing is y'all got 3 weeks to study. Bad thing is I got 3 weeks to get ready for it. So
you're not doing anything, you're all right.
no.
This shouldn't be adversarial.
All right. Was it over yet?
I don't know yet. I'm getting.
Refresh. Y'all have a good week. I will have your essays back next week. That's a promise.
So how long